You could sign a brand new will today, leaving every single dollar to your spouse. Lock it in a safe, and it still won't matter. If a routine piece of paper you signed 15 years ago names someone else, that old paper gets your money, legally, every single time. Under consumer finance law, a will is actually just a backup plan that only controls whatever leftover assets didn't get claimed by something else. To protect your life savings, you need to know the 5 specific things sitting in your finances right now that will legally override your written will every single time. 1. Federal law, ERISA and workplace retirement plans. The absolute most mind-blowing way a will gets overruled has zero to do with paperwork you filled out and everything to do with federal laws you probably never knew existed. If you hold a workplace retirement plan like a 401k, 403(b)(2), or company pension, you do not actually have total legal control over who gets that money when you die. Federal law holds the ultimate veto power over your private desires. Back in 1984, Congress passed a federal rule known as the Retirement Equity Act under ERISA to stop surviving spouses from being quietly stripped of financial security. Before this landmark piece of federal legislation existed, an individual could quietly change the beneficiary on a massive pension or corporate retirement account to a sibling, a friend, or a business partner, completely leaving a surviving spouse without a dime to cover basic living expenses, housing costs, or ongoing family debts. To permanently close that legal loophole, the federal government placed an automatic, indestructible legal lock directly onto all employer-sponsored accounts. Under this specific statute, the exact day you sign a marriage certificate, your new spouse automatically becomes the legal 100% owner of your workplace 401k upon your death. It does not matter if your last will and testament explicitly states in bold lettering that the entire 401k balance should go directly to your biological children from a previous marriage. It does not matter if you filled out an official company portal form naming your siblings, your parents, or a charitable organization. The federal statute completely overwrites every single piece of paper in existence. The moment you step into marriage, the law reassigns those funds to your current spouse by default. There is only one single way around this automatic federal rule. Your spouse must physically sign a legal notarized waiver explicitly surrendering their legal rights to your workplace 401k. That waiver cannot be handled over an email, a signed letter, or a verbal agreement recorded on camera. It must be executed in the physical presence of a certified notary public or an authorized plan representative. Furthermore, prenuptial agreements signed prior to the wedding date generally fail to hold up in court regarding ERISA accounts, because a person cannot legally waive spousal rights before they are legally recognized as a spouse. Without that specific notarized postnuptial document on file, your written last will and testament remains completely powerless against the federal government's default mandate. State governments also enforce their own powerful overrides through statutory protections known as elective share laws. In the vast majority of jurisdictions, the law strictly prohibits an individual from completely disinheriting a current spouse. Even if a decedent drafts a comprehensive will, leaving zero assets to an estranged partner, state statutes grant that surviving partner the legal right to challenge the will in probate court and forcibly claim a mandatory minimum portion of the estate, typically between 30% and 50% of the net wealth. Thus, statutory laws at both federal and state levels serve as an absolute veto power over whatever text appears on a private page. 2. Beneficiary designation forms, contract law. The second most explosive override, and the one that destroys families financially on a daily basis, is the standard beneficiary designation form. When you open an individual retirement account, IRA, purchase a private life insurance policy, set up an annuity, or establish an investment account, the provider requires you to fill out a brief document naming a primary beneficiary. Most people view this document as trivial HR paperwork or routine account setup administrative steps, completely forgetting its existence over the course of 20, 30, or 40 years. But under contract law, that brief form creates a direct, legally binding private contract between the account owner and the financial custodian. When you pass away, the financial institution does not report to a probate judge, nor do they pause operations to review a newly updated last will and testament drafted on your deathbed. They pull up their private internal database, verify the binding contract on file, immediately issue a lump sum check directly to the individual listed on that piece of paper, and mark the account officially closed. Because contractual payouts bypass the public probate system entirely, your last will and testament never obtains the legal jurisdiction required to govern those funds. If your private IRA form filled out in 1998 still carries the name of an ex-spouse, that individual receives every single dollar sitting in the account, regardless of what your current family situation looks like or what your recent will dictates. If you assume a probate judge will step in and overturn this scenario due to an obvious oversight, consider the catastrophic real-world precedent set by the United States Supreme Court in Kennedy v. Plan Administrator for DuPont Savings and Investment Plan. In this famous case, William Kennedy named his wife, Liv, as the primary beneficiary on his workplace retirement plan. Years later, the couple divorced. During the court proceedings, Liv explicitly signed a court-certified divorce decree waiving every legal right to William's retirement funds. The agreement was signed by lawyers, approved by the judge, and filed in official court records as a binding settlement. William assumed that the formal judicial divorce decree took care of the legal matter completely. Consequently, he never executed a new one-page beneficiary designation form with DuPont to officially erase her name from the corporate database. When William passed away years later, his surviving daughter and estate pointed directly to the signed divorce decree, demonstrating clear proof that Liv had legally surrendered her financial claim to the $400,000 balance. DuPont's plan administrator completely ignored the divorce decree and paid the entire $400,000 balance directly to the ex-wife, citing that her name remained on the primary contract document on file. The legal battle escalated all the way to the highest court in the nation. In a unanimous 9-0 decision, the Supreme Court ruled firmly against William's family. The justices established that under federal law, plan administrators are strictly required to execute payouts based solely on the official documents sitting in their plan files. The court-ordered divorce decree proved completely irrelevant. The deceased father's clear intent proved irrelevant, and the ex-wife walked away with the entire fortune despite having legally signed away her claim decades earlier. Contractual forms override personal intent every single time. 3. Payable-on-Death, POD, and Transfer-on-Death, TOD, tags. The third hidden mechanism sitting directly inside your daily personal finances controls liquid checking accounts, savings balances, certificates of deposit, and brokerage portfolios. Payable-on-Death, POD, and Transfer-on-Death, TOD, designations. A substantial number of account holders step into a local bank branch to open a standard checking account and casually ask the teller to add an adult child or trusted family member to the account as a backup, believing it merely gives that relative legal permission to step in and write checks for immediate funeral costs or emergency medical expenses if something sudden happens. In reality, adding a payable-on-death tag completely transforms the underlying legal ownership structure of those financial assets the exact second the primary holder stops breathing. A POD or TOD tag operates as a high-speed legal bypass that completely dodges the entire probate court framework and completely ignores every word printed inside a written last will and testament. The second the primary account holder dies, absolute legal ownership of every penny sitting inside that account transfers instantly to the individual listed on that bank card. Consider a common scenario where a parent drafts a fair will, instructing that their total estate, including a main bank account holding $300,000, should be divided equally among their 3 biological children. However, 10 years prior, the parent added the eldest child as a POD designation on that specific bank account to make utility bill payments easier during an illness. The instant the parent passes away, the entire $300,000 balance becomes the exclusive personal property of that eldest child. The bank will not divide the money 3 ways, nor will they consult the other siblings. They hand 100% of the funds directly to the single-named child. Unless that eldest child voluntarily chooses to write personal checks to share the funds, the other two children receive absolutely $0 from that account. A probate judge possesses zero legal authority to overturn the arrangement, because the liquid cash was legally transferred outside the estate before probate ever opened. 4. Property titles and joint tenancy with right of survivorship. The fourth major override comes down to the precise legal phrasing printed on your real estate deeds, land documents, and vehicle titles. How a piece of physical property is legally titled holds vastly more power than any instruction written inside a personal will. A massive percentage of married couples, as well as elderly parents who elect to put an adult child on a residential house deed to keep things simple, own real estate under a specific legal framework known as joint tenancy with right of survivorship. Under this titling structure, two or more individuals co-own 100% of the entire property simultaneously. The defining legal phrase in this arrangement is right of survivorship. This specific clause dictates that when one co-owner passes away, their personal ownership percentage does not pass down to their personal heirs, nor does it move into an estate to be distributed by a judge. Instead, their share instantly vanishes from existence, and the surviving co-owner immediately absorbs complete 100% sole ownership of the entire property by operation of law. This automatic transfer executes instantaneously at the precise moment of death, long before any last will and testament can ever be presented to a courtroom or reviewed by an executor. Imagine an individual who owns a home valued at $500,000. They remarry later in life and proceed to add their new spouse to the real estate deed as a joint tenant with right of survivorship. In their personal will, the individual explicitly states that they want their half of the home's financial value sold and distributed directly to their biological children from their first marriage. That specific instruction inside the will is entirely void under real estate law. The instant the individual dies, the right of survivorship mechanism executes automatically, wiping out the deceased person's share and transferring 100% legal ownership of the entire house directly to the surviving spouse. The surviving partner now owns the home outright as an individual. They have the absolute legal right to sell the property, keep every dollar of the cash, or draft their own estate plan, leaving the home exclusively to their own biological family, leaving the deceased person's children with absolutely nothing. The property title completely erases the instructions inside the written will. 5. Revocable living trusts. The final legal structure that completely bypasses and overrules a last will and testament is a revocable living trust. A living trust is an independent legal entity established during an individual's lifetime to hold, manage, and distribute their accumulated wealth. When an individual sets up a trust, they execute a legal process known as funding the trust. This requires physically changing the legal titles of their real estate, private business shares, investment accounts, and personal bank accounts out of their individual name and directly into the legal name of the trust. While the individual remains alive, they typically serve as their own primary trustee, maintaining total personal control over all assets. But the moment they pass away, an unyielding legal rule comes into play. A last will and testament only possesses the legal authority to dictate assets that were held strictly in an individual's personal name at the exact time of death. Because all property moved inside the trust is legally owned by the trust entity itself rather than the individual, a written will has zero jurisdiction over those assets. The underlying trust agreement rules supreme above all other estate documents. The successor trustee appointed inside the trust document steps in immediately and distributes the property strictly according to the detailed rules of the trust. If a will explicitly states one thing, but the living trust agreement states something entirely different, the living trust wins the legal battle every single time without exception. Preventing these legal conflicts requires taking 30 minutes today to conduct an audit of your active accounts. First, log directly into every 401k, IRA, brokerage account, and life insurance portal you own to verify that your beneficiaries match your current wishes. Second, contact your bank to verify whether any checking or savings accounts carry active payable-on-death tags. Third, Check physical copies of your real estate deeds to verify whether you hold property as joint tenants with right of survivorship or as tenants in common. Finally, treat every major life event as a prompt to update your accounts manually. Financial institutions do not track marriage registries or review divorce settlements. Those silent forms sit in corporate databases waiting for someone to pass away, and by then, it is far too late to fix the mistake.